So, when we speak of consent, consent is the foundation for privacy protection and individual autonomy in the data privacy framework. As a word, what does consent means? It means someone agrees to something. Now that access, when it's given, it can be tangible or it can be intangible. So when we speak of data, it holds the same importance, right? Now, DDP Act is no different than IPC. There is, when we speak of consent, there are various ways it can be taken into picture, but yes, consent holds a immense importance. So consent manager, who is he? Now, clause 3, subclause 2 of the Act defines consent manager as a data fiduciary, which enables the data principal to give, withdraw, review, and manage his consent through an accessible, transparent, and interoperable platform. Now, India is an incredibly diverse nation. Thereby, operationalizing effective consent would need more than legal and regulatory controls. Under the Act, consent managers are third-party entities that will digitally enable consent through an interoperable technology framework. Also, please know that India will be the only country to statutorily recognize and adopt a tripartite model for data sharing. So, a data principal, a consent manager, data fiduciary will all act one and together. So let's just take a recent example. I mean, 2021, it was RBI which launched, the data fiduciary, which will enable this whole concept under account aggregators. So they launched to facilitate the consented transfer of financial data between regulated financial entities like banks, insurance companies, pension funds, etc. The account aggregators, which was started by RBI in 2021, were approved independent entities who were tasked to obtain, to submit, and manage customers' consent through a technical framework that incorporates legal principles for consented sharing. In essence, they were the consent managers in the financial sector and were referred to in the, like how in the current act we are mentioning consent managers under clause 3, subclause 2. So now when we speak of the genesis and the importance of consent manager framework, it was India's decision to adopt a fiduciary approach to privacy protection as per the Sri Krishna Committee recommendation, which I did mention, before when I spoke before. It said that it is very evident in the objectives and provision of the Sri Krishna bill, recommendation which was taken into data privacy bill. It said that one needs to make an effort to establish the concept of trust, and that trust will only be enabled when there's a person who is a licensed authority, so trusted by the entities, but also a person who will also will be trusted by the by the users, the data principals. So with rights and imposed obligation and being a licensed authority, consent managers hold a lot of responsible role in this whole framework. Now, as consent managers under the Act, they are independent entities. Okay, and they're entrusted to manage data subjects, consent for sharing data through an interoperable, secure, and transparent platform. They will be regulated by the Data Protection Authority, and they will operate within the paradigms of the electronic consent framework established by MeitY, which is Ministry of Electronics and Information Technology. MeitY has also released a set of technology standard for such electronic consent. Now, how would these consent managers work? So there are 3 participating entities within the consent manager framework. One is an information provider, who are the original custodians of the data. These entities will collect and store the individual's data. Now, the second is information users. They are the entities who will require the data from the data subject for providing certain services. And finally, the consent manager, the most important role, will be the entities licensed by the authorities to facilitate consent for sharing data. All 3 will operate over a common network, which will be based on specifications provided by the authority and Ministry of Electronics, Information Technology. The application will be created, which will program interfaces, will be developed to connect to the network. The government will impanel independent certifying agencies to confirm compliance with, with the required standard for all the participants. Once the consent manager system becomes operational, the following steps must be taken to ensure compliance, and that will be, with regards to how they will be selected, how the information user will provide information, how the services they want to see it, that what kind of services they'll be giving the information to. And once chosen, the information user will send an electronic data transfer request to the consent manager to fulfill the service request. Now, these are the technical aspect. We are still looking for a complete rule book on the same. But nonetheless, when we speak of banking sector, blockchain technology is being used heavily for data localization, data protection, and at the same time data assimilation. And the role of account aggregators, as mentioned, for the RBI, which was started in 2021, is now adopted by many banks like HDFC, Kotak Mahindra, ICICI, State Bank of India. I mean, there are some of the many examples that I could think of right now. But yes, AAs that are account aggregators have received in principle approval from the RBI to operate using the standardized consent artifact released by MATI and detailed rule book given by RBI's master circular. Significant privacy features of the consent artifact has been included, which will talk about establishing the identity of the participants, logging of consent flows, consent verification, the revocation of consent, the security standards, the purpose, limitation, the storage, the user limitation. So account aggregators will operate within the consent artifact's strict paradigm. They cannot access, view, or store the data flows between the information provider and user. They will operate similarly regulated by the Data Protection Authority and MATI. So how will they play this critical role? So when we speak of consent, the Act sets a principle for data protection and does not prescribe guidelines for consent as of now. The role of consent manager is extremely vital and critical in standardizing that consent. Companies that can leverage this framework could have a significant advantage in complying with the requirements of the data principles, right, and increasing consumer trust. Now, consent can be of many kinds. It can be consent for sharing, and it has to be an informed and categorical consent. It has to be a consent which is linked to a purpose. The consent for withdrawal, the consent for collection, the consent for repurposing and sharing data, and also consent must be demonstrable by the data fiduciary. Standardization, accuracy and quality, consumer trust, privacy embedded into the design are some of the features given into the structure of consent managers' working framework. Now, when we speak how companies will prepare themselves to participate with consent managers, we feel that organizing information for consent preference management is the first step. Companies should be ready to effectively process and manage data privacy subject request as the law gets enacted and has been enacted now. The compliance of the same will be taken care in coming 10 months. It will be done in a phased-wise manner, but the data subjects with regards to consent, sharing of data, the access, the retention, the deletion is extremely crucial. So having a framework is very important. The context of corporate entities will need to be determined now. The role as of data users, data providers, and with regards to data fiduciary in the context of the services will now needs to be structured in all the corporates. It has to be categorized services, and the personal data proceed against each other service could be a good starting point. One has to develop a team within the company. An entity should need to dedicate teams to understand and communicate the security standard, reporting and technical requirements. From KPIs to audit trials, participants in this framework should develop KPIs and audit logs to communicate to the customers and the authority that how data has been produced annually to the customers and how it has been removed, or how they can enable transparency for them to showcase where and how the data is being used or was used or has been removed. Now, when we speak as lawyers and when we speak as public policy professionals, one of the most important part is grievance redressal mechanism. Companies will now have to and should create internal grievance unit for redressal and guidance under Data Privacy Act. So, yeah.